Hi, folks. It's Denise Howell. And next up on This Week in Law, we're going to talk about mistrial by internet, the effect of Twitter on courts and the media, and what's to be done about it. We're going to talk about Facebook's control over your online identity. We're going to talk about video codecs and the patent submarine. You don't know it's out there, but it's waiting for you. And we're going to find him here on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 95, recorded January 21, 2011. We all live in a patent submarine. This episode of TWiL is brought to you by MailRoute. Businesses of every size use MailRoute. One user, 50,000 users. It doesn't matter. MailRoute will protect you from spam and viruses, simplify your life, and make your email usable again. Visit mailroute.info to sign up and get 10% off the life of your account. Hello and welcome to This Week in Law. I'm Denise Howell, your host, and we've got a great panel of folks this week to talk about all the current developments regarding the internet and the law that touch your lives every day. We've got really wonderful people to chime in on those thoughts for you here today. My old friend Kevin Marxist is joining us. I'm so happy to finally have you on the show, Kevin. Hello.
Hi there. Very nice to be here.
Great to have you. Kevin, for folks who are not familiar with him, is a British telecom person based in San Jose, though, correct?
Yes. Yeah.
Yes. And
I've been in Silicon Valley since 1998 now, so coming up for 13 years in April. So I'm almost more American than British now, but not quite.
Not quite. Longtime blogger at eps.blogspot.com, a Gilmore Gang member, one of my favorite other shows to catch weekly, a Tumblr at Tummelvision, your great show there, dad of creative young boys, all-around Renaissance guy. So happy to finally get the chance to chat with you for a while. Also joining us for the first time, Eric P. Robinson, the Deputy Director of the Reynolds Center for Courts and Media at the University of Nevada, Reno, a contributor to the Citizen Media Law Project, and a blogger at, is it Blog Law Online?
Yep, that is it.
Great. So it's wonderful to have you on, Eric. Thank you for taking the time to join us.
It's nice to be here.
And joining us again is Evan Brown, AI enthusiast, lawyer extraordinaire at Hinshaw and Culbertson, blogger at internetcases.com, and a regular here on TWiL. Hello, Evan.
How's it going? Happy Friday to you, Denise.
Happy Friday to you. It's going great.
Good, good.
Great to be here with you all. So I wanted to start out on a topic that's sort of up Eric's neck of the woods, given his emphasis on courts and media, and this notion that we see week in and week out. Just, you know, Evan and I have mentioned this before on the show. You just can't begin to browse through stories on a weekly basis that relate to technology and law and their intersection without hearing about how some trial has been tanked, led to a mistrial, or otherwise affected by having Twitter or internet access for the jurors, you know, plain old going home and web browsing and researching the case. It's having a huge influence on our judicial system. So why don't we start with Eric and have you discuss this concept of mistrial by internet, and let us know what on earth courts are doing to deal with this. It doesn't seem like something that the tide is in any way being stemmed. It seems like it's getting worse and worse on a daily basis. Do you agree?
Yeah, well, the courts just, at this point, are trying to figure it out and trying to figure out how to deal with it. As you said, you know, in this age when everyone especially has a smartphone in their pocket, or many people do, and have the access to the entire internet, and a lot of people, it's just second nature to tweet, to blog, to instant message on a, you know, very frequent basis. They don't, at least initially, understand that in a courtroom context that might cause a problem, and might create issues for the court, for the judge, for the parties of the case, if it's a criminal case, for the defendant. And there are lots of issues that the courts are really having to grapple with these days. It was traditional, as I'm sure the listeners, viewers know, traditionally, judges would tell jurors not to read about a case, not to talk about a case. And whether they actually followed that or not, it was more or less could be contained in terms of the information that the jurors were receiving. But now there's this constant stream of information, both coming in and going out, that people can access. And the courts are really struggling with how to deal with that.
So here's my concern about this. Yes, for years and years, we've instructed jurors, not to communicate about the case, not to taint their views with media coverage of the case, or do independent research about the people involved. And that has become easier and easier. But it's also just completely unrealistic from my standpoint to tell people, thou shalt not touch the internet while you are on a jury. And it seems like, that's what the federal judges are advised to instruct juries. It seems like we've just got this divergence of instructions from reality, and we're going to wind up further limiting our jury pool. I mean, nobody wants to participate in jury duty as it is. Now, that's a broad overstatement, but there are plenty of people who fight tooth and nail to be able to not serve on a jury. It interferes with your life. You've got work responsibilities, childcare responsibilities. If you can get off a jury, phew, you have some out. And that leaves us, though, with a handicapped and crippled judicial system that really can't give people the trials that they deserve. And this strikes me as a way of just aggravating that problem. Evan, do you agree? And do you see any solution to this?
Well, I think I tend to go more on the side of respecting the traditional sanctity of the forum. And, I've talked about this before. I wrote a blog post at the beginning of last year where I took a very conservative stance on this issue. The post was called... it included, the post was some thoughts on jurors doing internet research, keep the process clamped down. And I think the important thing to do is to recognize kind of the internal conflict that most people are going to feel here. Maybe it's not so much an internal conflict, but they certainly will feel conflicted for whatever reason. There's this natural tendency and this natural impulse to want to both share information, putting out a tweet or updating your status or checking in somewhere. And there's also this natural tendency that's magnified by having mobile devices and the ability to run searches and find out information wherever you are. That's generally a good thing. And that serves us all very well in everyday society as thinking people who want to pursue the things that we're interested in and communicate with the people that we want to communicate with and share ideas. And then we can quickly escalate this line of thinking all the way up to, the nobility of democracy and all of that stuff and the information marketplace and all of that stuff. But a jury trial is a very special set of circumstances that in so many ways is carved out from everyday life, not only in terms of the information, but also the other rules that go along with it, the rules of procedure. Things have to go in a certain way. And the rules of evidence, even though they've been around for a long time, one can think of them really at a very fundamental level as information filters, a certain framework so that only certain information gets through. And then once it gets through, it's presented in a certain way. And if we're going to, in so many ways, circumvent that framework that the rules of evidence put in place for us, we're really circumventing something that's very essential to the integrity of the whole system. And I don't see any other solution. It's hard, I guess what I want to say is it's hard for me to see much middle ground here because of the fundamental importance of that filtering and contextualizing effect that the rules of evidence have here. It's hard for me to think of some middle ground letting, holes in that filter get too big. That's my thinking on it. I think I generally tend to be pretty conservative on this issue.
Yeah, I mean, with good reason. You don't want to, once you do have a seated jury, you don't want them to be tainted by things outside the courtroom. They need to focus on the evidence and weigh it and resolve the case within those parameters. But at the same time, I think we're in this untenable situation, and it makes me wistful for the kinds of things that the technology arena does when they find themselves up against seemingly insurmountable roadblocks. That the legal profession doesn't so much do this, but maybe it should. And I'm thinking, Kevin, of the kind of hack days that people sponsor and get involved in, and just throw as much brain power at a problem as you can and see what kind of solutions you could come up with. Do you have any unique insights on this issue, Kevin?
I think it is a very difficult one because of the issue of admissibility, because we are now so used to being able to look things up that we don't bother remembering things. I mean, the jury aren't expected to forget everything they already know. They're told to not take that into account, but I'm sure jury discussions involve their pre-existing prejudices and knowledge. So for most of us now have this penumbra of other knowledge that we know about or know where to look for, or know, if I have a legal question, there are places I can look or people I can talk to help me with that. And it would be very, very difficult to operate outside that space. And also, I think, as you said, it'd be much more difficult for someone to become a juror.
Oops.
Whoops.
I think we just lost Kevin.
Denise, can I add something?
But along the lines of what he was just saying, I think I know where he was going with that, because as I was reading through this stuff in advance of the show, I was thinking, well, our tip of the week could be, and this is completely tongue-in-cheek, I would never encourage somebody to do this, because we do indeed need good people on juries. The jury pool needs as many broad and well-educated and capable people as it can get.
Renaissance people. Right.
Exactly. But if you were in desire of getting yourself off a jury, I would think that a good old-fashioned, really unkickable internet connection, or not connection, but addiction, would be something you might want to toss out there. Gee, Your Honor, I simply can't. It's my work. I can't be offline. I have to be exposed constantly to the incoming stream of information, and who knows, it might well get you off a jury. Today's day and age, since the mistrial issue is a really big one. Eric, I guess that the specific story you were interviewed about involved a murder trial. Is that right?
Yeah, it was a murder trial where one of the jurors did some internet research about one of the terms that had been thrown around in court, and shared that information with the other jurors. So the judge decided in that case, because the information had been shared with the other jurors, that the whole jury was tainted and there had to be a mistrial. There's just one thing I wanted to add to what you were saying before. I mean, the solution it's not a great solution, perhaps, but the solution I've been advocating is that you can't just tell people anymore that they can't read about the case, they can't talk about the case. I think you have to explain why, that there are rules of evidence, right, and that there are reasons for these rules of evidence, and it's to protect the integrity of the system, the fairness of the system, and and constitutional principles, and all that plays into that. I think you just have to appeal to people's higher nature and it might sound trite, but their sense of civic duty when they're on a jury, to not go beyond the bounds of what's in the courtroom when they're, making a decision about a case.
Right. I think that's an excellent point. I think often jurors are given this long and sometimes incomprehensible set of instructions of things that they're supposed to do as they deliberate about the case, and they're just expected to obey. It's kind of like telling children, thou shalt do or do not do this, and if they don't know the reason behind that, odds are they're just not going to listen to you. Kevin, you're back. Were you going to say something about about how people were not going to be eligible for juries because of their need to be in touch with all this information during a trial?
Well, I think it's if you say to me, okay, you're going to be on jury service and for 6 weeks you can't touch the internet, that would, that's worse than you can't work for 6 weeks. That's really hard.
Yeah.
And also if you want to be judged by a jury of your peers, you want someone who actually understands the world that you live in. And if your only people allowed on juries are the ones who've never touched a computer, then there's a problem.
Agreed. Well, the other way that this comes up a lot, and I'm sure the Reynolds Center, Eric, must deal with this issue as well, is not so much computer usage by the juries in courtrooms, but by the observers in courtrooms, be they journalists or just citizen journalists who happen to be there and something interesting happens and they have their electronic and always-on connected device with them, and the news goes out to the world. Over in the UK, a Lord Chief Justice, goodness, I love what they call themselves in the judicial system over there, in the Assange proceedings was confronted with the question of whether he was going to allow journalists and others to tweet from the courtroom. And he determined that as long as it was unobtrusive and it wasn't disturbing the proceedings, why not? It was not a closed courtroom. There was no reason for secrecy. And that's a controversial decision. It doesn't sound like it might be, but there are plenty of courtrooms here in the U.S. where, cell phones are not allowed near them, nor anything else that would allow you to communicate with the outside world. Eric, what's the status on that?
Well, you're right. It's all over the map, literally and figuratively. Courts have very different policies, and in a lot of courts, it comes down to the individual judge and how comfortable they are. There's a reporter in Kansas City, for example, who regularly tweets from the courtroom, from all the courtrooms there, and he talked. I mean, the important thing he did is he spoke to the judges beforehand and told them what he was doing. And there are other courts, like you said, that collect cell phones from people who are going into the courtroom or the courthouse. And then there are some courts that have, most courts have old rules about broadcasting that were, adopted in response to television coverage and television cameras. And some courts have actually applied those rules on the rationale that if you're sending a signal, you're broadcasting.
Right.
So
I remember something about this from last year. Wasn't there an amendment to the Federal Rules of Civil Procedure that involved broadcasting and prohibiting it that was now going to apply across the board?
Well, they issued it wasn't an amendment to the rules. It was more, it was essentially a memo from the Administrative Office of U.S. Courts dealing with this issue and basically saying that the same, the rules as they existed applied.
There was also a case down in the Middle District of Georgia called United States versus Shelnutt, where a local reporter had petitioned the court for access to be able to use his handheld electronic device in the proceedings, and the court ruled that Rule 53 of the Rules of Criminal Procedure prohibited it. That's a prohibition on broadcasting without permission of the court. So I don't know if that plays into our collective memory somehow of what went on there.
Yeah. Evan, have you ever blogged or tweeted from court when something notable happened?
No, I don't like the appearance that gives. Sometimes I'll put up a tweet saying, I'm on my way to court, just in a very general, statement of, what I am, what I'm up to remind my followers, that I am a lawyer and I do practice law and I know about this stuff. But I just, from a personal level, I'm not making any kind of ethical judgment or saying that somebody's violating the rules of professional conduct when they tweet about their cases or something like that. But I just, for me, in the way that I like to portray myself as a lawyer, I don't like talking about my matters in much detail.
Yeah, but I've certainly, my practice involves an appellant component, and I have been at court on cases not my own that were important cases where there was a lot of bated breath waiting for the decision, and I happened to be there in a crucial argument or what have you, and was able to, sort of, you can never know what a court's going to do, but you can tell by the questions that are being asked what the justices are interested in, and you can draw some conclusions from that. And, when you're on the ground right there and able to get it out there, it's really useful and valuable for people,
Well, I guess I did. I was at the federal courthouse here in Chicago on the first day of Rod Blagojevich's trial, so I'm sure I did tweet about that. So maybe there you go.
Yeah, there you go.
We're talking, that's historic.
Right. Okay, so along these lines, I'm going to go ahead. I usually save our tip and resource of the week for the end of the show, but since we've been discussing the Reynolds Center, which you can find on Twitter at Courts and Media, that is our resource of the week for this episode of TWiL. And Eric, why don't you describe for us the work at the Reynolds Center and what people might find if they go there, and also your conference coming up next week.
Yeah, well, thanks. The Reynolds Center for Courts and Media we're part of the journalism school here at the University of Nevada, but we also work with an organization and are actually at least temporarily housed in a separate entity that's on the campus but not part of the university, called the National Judicial College, which does training for judges on various issues that they have to deal with, including these. And what we examine is the intersection and the interaction of the courts and the media and how they interact on various levels, coverage of the courts, access to the courts, and also how the courts use media in their proceedings, in their processes. And next week, we're having a conference in Houston, kind of looking at some of the issues that arise when you have a highly publicized case that gets a lot of both traditional media coverage and social media, and new media coverage. How does a court deal with that? And traditionally, the way to deal with that is to move the trial. You move it from Houston to Dallas, for example. There was talk, in the shooting in Arizona, of moving it to California because of all the publicity that incident has gotten. But in this modern media age, can you move a trial anywhere within the United States where people haven't already heard about the case? Modern media being what it is and being so ubiquitous is, it's national in scope now. So
right,
moving
it's sort of the flip side of the coin from the jurisdiction question. You used to have to have minimum, well, you still do, have to have minimum contacts with the place where you're being sued and the trial is going forward, et cetera. In today's day and age, minimum contacts where people are doing business globally, potentially,
right,
sort of becomes less relevant. And it seems like, the same sort of situation happens when you're trying to decide venue issues.
Right. Well, there's also, with the internet, there's what you're talking about, jurisdictional issues. If I have a website and someone clicks on something, I'm in Nevada, someone clicks on it in New York, and something goes wrong, can they sue me in New York? Do they have to come to Nevada? That's also a big issue these days.
Right. So Kevin is one of the first people, longtime sort of video hacker guy. One of the first people I recall live streaming a conference. I think it was one of the identity conferences in Denver, perhaps, Kevin, if I'm remembering right, years ago now. You had your Mac. You had your built-in camera on your laptop. You aimed it at, I think it was my panel, may have been other panels. And we're live streaming what was going on there. And I remember blogging, oh, hey, there's a live stream. You can watch what's going on via Kevin's computer. And, that's become more and more commonplace. Lots more people and organizations and events are live streaming in an official capacity since that originally happened. And I'm wondering, though, courtrooms are so far behind the times. What sort of chaos do you think Kevin would engender if he showed up with his laptop and a camera at a high-profile court proceeding today, Eric. And how do you think it would be dealt with?
Well, it would really depend.
That's sort of a step removed from simply tweeting.
Yeah. It would really depend on the individual judge who's presiding in that courtroom. I'm presumably Evan, as a smart journalist or lawyer, whatever.
That's Kevin.
Role.
We have a Kevin and an Evan today.
Sorry. Sorry about that.
Okay.
But hopefully he would have spoken to the judge beforehand. I mean, that seems to be from the journalists and citizen journalists that I've spoken to who have done this, that seems to be the key, is to not just show up with whatever equipment you're going to use, but to talk to them in advance. And I mean, essentially as a legal issue, whether you have to get permission or not is arguable, but just as a social courtesy, not creating problems for yourself, that seems to be the best way to go. A lot of courthouses now have free Wi-Fi. So, I mean, I was going to talk about this before, but there was a case, and I'm forgetting which state it was now, where a lawyer actually had a laptop during jury selection and was Googling people as they came up to be selected for the jury, and was rejecting or accepting people based on what he was able to find. So, it can be done, and, the legalities of it, I mean, as a lawyer, I'm reluctant to say the legalities of it, putting the legalities of it aside. But if you don't want to have to, make a legal argument about it, it just makes sense to actually speak to the court personnel and tell them what you're doing.
Well, the difficulty now is that, I have 2 high-definition video cameras in my pocket because I'm carrying an iPod and a phone there. So anyone who's, half the courtroom could be surreptitiously recording the place just by having that, taking that out and pressing a button. So it's much more difficult. The laptop gear I was using 5 or 6 years ago was fairly obvious. It was this big and so on. Now it's like, little thing like this happens to have a camera in it. And you may not know I'm using it at all. I may be sitting there in the courtroom holding it at all. So maybe that's where you're talking about confiscation of devices. But it's assumed ubiquity now.
Yep, absolutely. Evan, any final thoughts as we round out this topic and move on?
Let's just go back to some kind of primitive system where we all just communicate by Morse code. I guess that's going to do it.
Absolutely. All right. Well, one more primitive system that we all communicate by rather than our wireless phones, et cetera, is good old-fashioned email. And we have a few things to talk about there. A couple of cases just worthy of note. Nice write-up by Orrin Kerr about a decision from the, let's see, which circuit was it? One of the federal circuits.
It was the 6th.
The 6th, thank you. This was a while ago now. It was actually back in December, and the EFF had submitted some briefing in that case, and lots of folks were very excited, polite clapping for the court, that they decided that the federal government should view email as a zone of privacy when people do, expect that this is not something that's going to be readily available for perusal by a federal government official. So Fourth Amendment protection was found to apply to email, even though, it's got its security issues and everything else, and there are various ways that it can become public if the people in this case had a reasonable expectation of privacy and a warrant was thus necessary to access the email accounts for investigative purposes. And then another sort of related kind of an issue in a different case different part of the country. Let's find out what part of the country that was. Is a gentleman who was accessing his wife's email to see what she was up to, and did so in sort of a way that could be subject to challenge under the Computer Fraud and Abuse Act. In other words, she hadn't just left it open on the machine. He wandered by. There was some gleaning of her password, etc., and surreptitiously accessing her account. He was actually charged criminally for doing that. So there are some cases where courts are erring on the side of, this is a private kind of a context, and people's expectations of privacy are going to be honored in judicial kinds of settings and for evidentiary and evidence gathering purposes. So just throwing that out there. Evan, any thoughts on these two cases and the principle that they're putting out there and seems to be developing?
That's one of the silliest cases I've ever heard of, that Michigan case. And I mean, I think we need to be clear. This is just an overzealous prosecutor. We don't know anything of what the judges and what the courts are how they're going to apply how the court is going to apply its good sense to this. But I just think that's ridiculous that there would be some kind of invasion of privacy. From what I understand it, it's a Michigan state statute that the guy is being prosecuted under. So, I mean, that makes no sense to me because of the facts underlying it. This was the guy's own computer. He bought the computer. I guess the theory could be that if this was a cloud-based email application, then the access truly was to more than just that particular computer. But it just really makes no sense to me. I'm
surprised. Yeah, this one doesn't. I mean, I think charging him with a felony or something would be rather extreme. But if he's surreptitiously gaining access to somebody's email account, the fact that it's someone he lives with, I don't know that that's necessarily something that would protect you from criminal liability.
Yeah, this is really tough when you get into these domestic relations cases. I think that's maybe what's clouding my, I don't want to say clouding, but that's what's giving me a certain spin on this, because a family court, a domestic court, is a court of equity, and there are larger issues at play than just the legal issues of whether or not somebody violates this statute by doing this. I mean, after all, the guy was gathering information, and he was successful in this regard. Whether or not it was legal for him to do so, he was gathering information about his wife's philandering with her second husband. This was her third husband, who's the one who's being charged. She was cheating on him with the second husband and doing things that were harmful to the children. So as we all know from when we've studied domestic relations law, whether it be in law school or studying for the bar or whatever, nothing matches this notion of the best interest of the children. Whenever you bring that into the equation, everything kind of blows up and you forget about everything else, and all you think about is the best interests of the children. And so that it's unusual in a domestic relations case, if there are children of the marriage, for the issue of the best interest of the children to not be present in the analysis. So, in those types of situations, there just seems to be a different calculus, and we need to have a broader perspective. There are a couple of other cases that are kind of relevant, or along these lines, first cousins to this issue. There have been some cases where evidence has been excluded because the wife had installed spyware on the husband's computer. There was a Florida case back in 2005. So, I mean, you see these kinds of issues, but in certain human contexts, we've got to, as smart people, we've got to look at it, in a broader perspective than just the technical legal violation of this, statute that prohibits unauthorized access to a computer.
Kevin, you're married. If your wife were, of course, completely unjustifiably suspicious of some activity you were engaged in, and engaged in some social engineering or otherwise gained unauthorized access to your email account, do you think that it would be justified for a prosecutor to charge her with a crime?
I'm confused by this because in many of these cases, the email records are subpoenaed anyway, aren't they? Certainly, I know friends of mine who worked at Hotmail and Gmail expect a sort of weekly burst of domestic subpoenas for exactly this kind of reason. So is it just a admissibility issue because they didn't follow process?
Yeah, that's it. Maybe there would have been a way to gain access to the information and discover what it was they were trying to discover about the actual substance here of, whether the children were being harmed by the activities.
Right.
But yeah, to just, eschew the whole formal discovery process and hack into somebody's account, if you want to call it hacking.
Those computer misuse statutes are a bit odd anyway, because they have some sort of like 1980s mental model of how computers work. There was a case a couple of weeks ago where the EFF managed to say that not download your email from the server didn't mean that you didn't want it, which was something like that. There was this sort of assumption in law that if you kept the email on the server, then it was fair game for people to read it without a warrant. But if you downloaded it to your own computer, it was different. And that was the sort of the model of email from the 80s, where you always downloaded it, looked at it, rather than keeping it in the cloud. Whereas now pretty much everyone keeps their email, or at least a copy of it, on a remote server as well as on the local machine.
Right. Eric, any thoughts on this one?
Well, I mean, he makes a good point about the law does not deal well with new and fastly evolving technology. And a lot of the statutes that we're kind of weaving our ways around in internet and modern technology were, written, even if they were written 10 years ago, were written for a totally different paradigm. And it's very difficult for legislatures and courts to deal with that. And that's always been the case, but it's just that the pace of new technology is just overwhelming the court's ability and the law's ability to deal with it.
Okay, well, this leads us to our tip of the week, which is related to this discussion. And that is, though your personal emails may be private from the government and perhaps your spouse, don't ever do private kinds of things on your work email. I don't know why in today's day and age people would still be doing this, but they do, and it comes up in cases, and it did in California. Court of Appeals has ruled that a woman who was communicating with her attorney regarding suing her employer, in other words, she was bringing a discrimination case and was talking with her lawyer about the circumstances giving rise to that case on her work email account, that was all completely fair game, of course, to the employer, because the employer had a policy in place that said your employee email is not your own. You should not be doing personal business on the company email accounts. There's no reasonable expectation of privacy, et cetera, et cetera. And the court said, yep, that's right. So, if you're going to be doing personal things, don't use your work email. This has come up time and again in various cases in different ways. And this is just another confirmation that, you need to be church and state about the way that you communicate using company assets. Evan, any thoughts on this one?
Yes. I mean, this is like so many of the issues we talk about, nuanced. The tip that you gave certainly is a good one. Just don't put yourself in this situation of raising the question of whether you have privacy in your work-related email. But, there have been some interesting litigation over this. There's a case called Beth Israel is one where it was a New York case where the guy actually, it was found that he did have I can't remember what the outcome of that one was. I know there have been some cases where it has been found that, given the circumstances, there was an expectation of privacy in the email on the work computer, and that the attorney-client privilege protected that from disclosure. But it's very fact-specific, and most employers who write these policies are smart and very overreaching. But we also should bring up the notion of that. And I don't know exactly the procedural way this is articulated. It's within the Byzantine administrative structures of the National Labor Relations Board, but there was that administrative complaint filed against that company for disciplining its employee for bad-mouthing the company on Facebook. And one of the other, and it was because it was the NLRB, the National Labor Relations Board position is that is an unfair and unlawful restraint on the concerted action to form unions. And I know that one of the other allegations in that matter is that the policy, the workplace email policy, was too restrictive in as much as it prohibited certain types of communications that the employees would have or could have between or among one another about unions and stuff like that. So as with anything, there are all kinds of interesting shades of gray that make for good discussion, and this situation is certainly no exception to that rule.
Right. One of the nuances is that not too long ago, the New Jersey Supreme Court, and there's a good write-up by David Kravitz at Threat Level on this case and the one that we just mentioned in California, where the email account in question was a personal web-based email that was being accessed from work, and there was no clear policy that prohibited that, or So in that particular case, where the company was trying to get at that email, it would need some sort of formal process to be able to do it. It couldn't just, go onto a server and check and see what had been going on there. And the privilege wound up being preserved. So, that's one of the nuances. There are several, and I bet Kevin is thinking of some of them even as we speak. Any thoughts here, Kevin?
There's lots of complexities to this because there's also the interception laws, and there's a sort of strong push by government to maintain their ability to intercept communications based on the presumption they were able to intercept phone calls. And so they're trying to sort of push case law through, saying, well, other communications are kind of like that, so we want at least the list of who you called and contacted. So we can do that, and also we'd like to be able to intercept things with a warrant too, and trying to apply that to as precedent for emails, for Facebook messages, for any other medium as well, and that is problematic because certainly people have different sort of mental models of that.
Right. Eric, any thoughts about email and personal and private zones and the blending of the two?
Well, I was just going to amend your tip, is that the law is a bit murky, but to be safe, even if you're using a Gmail account or some other outside provider, if you are using your employer's computer, there's a risk that your employer has a legal right to see whatever you're doing on that equipment. It's the equipment. It's not just an email account. It's that you're using, something that is owned by your employer, essentially.
Yes, absolutely. That's a good addendum, and we've talked about that on the show before. There are plenty of cases out there that say that, if you're using work-related, employer-issued equipment and accounts for internet access, and, there are written policies that accompany the use of those materials that you're going to be bound by those policies. And every smart business is going to say that you're not allowed to do your personal stuff and that there's no privacy in your personal stuff if you're using your work-related machines to do it. And of course, this is like one of those clashes, much like the juries and trying to bar their internet access. You can't really ever enforce that. Of course, if there's an employee who's traveling and he or she has her work issued laptop, but she's on the road and she's got to, communicate with the family and do other business while she's out of town, personal life doesn't grind to a halt simply because you're traveling for work. And you may only have the luxury of bringing one device with you to take care of all of that. So that was one nuance I wanted to bring up. Another one is the fact that it's trivially easy, I think, using most webmail programs. It's certainly easy in Gmail to have that account be able to use your work address. So, you can be Kevin@bt.com from your email account as long as you set it up to do that. And that raises a whole other host of issues, because then, you're probably violating company policy if you do something like that. You need to double check before you do go ahead and do something like that, because companies try to maintain very close reins on their work-related communications. So if it's all of a sudden on Google servers and the IT department doesn't know anything about that or have any control over that, the company's going to be upset. So
someone also mentioned if you're at work and using their networking equipment, so even if you've got your own computer but it's plugged into their network, does that potentially create a liability, because then you've used their provided resources in a similar way, and therefore they can claim to be able to intercept it with impunity?
Yeah, I think that's another.
Not sure if there's any precedent there or not, but I think certainly see someone making that argument.
Yeah, I'm not aware of any precedent there, but I think that for businesses that have Wi-Fi throughout, that if we're not already seeing policies on this, we will be, that personal business not to be conducted on the company Wi-Fi, and if it is, here are the various stipulations about that. There is no privacy, we have access, et cetera, et cetera. I think companies are going to try and cover themselves that way if they're not already.
Yeah, I mean, the way these things have been written for years is they define this word system so broadly that it would include everything, known now and everything that will be used in the next 500 years. And so, I mean, it all, rises and falls on the unauthorized use of that system, or the use of that system. So, I think you could probably take a workplace internet usage policy from 1995, and it would still, prohibit, or it would still serve as a waiver of that expectation of privacy for most employees, even using a Wi-Fi enabled iPad.
Yep, exactly. So before we leave the topic of email, I want to go ahead and thank our sponsor, which is right up that alley. And our sponsor for today's episode is MailRoute. Businesses of every size use MailRoute. You can be someone who has your own private web server and your own private email on it that you are maintaining for all of the reasons we've been discussing, or you can be a business up to 50,000 or more people, and MailRoute is going to be very helpful for you because it's a secure hosted service that filters virus and spam for individuals or companies of any size. You can have tens of thousands of employees, and MailRoute will still eliminate viruses and spam and reduce the load on your email server simply by handling all that before it ever gets to you. Typical MailRoute customers see a 95% reduction in their inbound email volume. Think of that, 95% of the stuff coming in is nefarious or just useless material that no one wants to see, with virtually no false positives, which is just great. We have a couple of folks here at TWiT who are longtime loyal MailRoute users. Leo, who has been using his email address, leo@leovell.com forever and ever and ever, is able to use that address because he has MailRoute set up on it. And so even though he is a wildly popular and well-known person, he hasn't had to abandon that email address because he is a MailRoute user and fan. Tom Merritt, same thing, has his longtime email address that he actually was able to resurrect by using MailRoute to de-spamify it. There's nothing easier for email filtering than MailRoute. There's no hardware or software to install. You just sign up, and then you change your MX records to start your mail flowing through them, and they do all the work for you. So visit mailroute.info to sign up. As a TWiT listener, you'll receive a 10% discount for the life of your account. Small business accounts start at $2 per user per month for 10 users. And because of demand, MailRoute has added a new service for individual users, less than $30 a user per year. So visit mailroute.info and sign up with the email filtering service that Tom and Leo use and that we love here at TWiT. Thanks so much, MailRoute, for your support. Okay, guys, we've been talking about email. Let's move on and talk about some other interesting things that have been going on. Kevin, I particularly wanted to get your thoughts on and have you explain for us, because I think even though we're a legal show, there's a lot of nuance here on the technology side that makes this a complicated issue for anyone considering it. What's going on with video codecs? And why do we care? And what does this mean? What does Google's recent announcement regarding H.264 mean for everyone? And you know, how is all this laying out?
Okay, well, there is a lot of history here. So the basic issue, for what a video codec is a coder decoder, and what it does is it takes the picture, chops it up into little squares, and then compresses them, sends it over the wire, and then decodes it at the other end. And the protocols for doing this have been, under development for years, and many of them have patents applied to them. And this is, and we can get into the bad idea that software patents are, but also this applies to hardware as well. A lot of these patents date back to when video had to be implemented in hardware and couldn't be done in software. And there is until like last year or the year before, there were many competing video formats on the net. There was Windows Media and Real Player and QuickTime and Flash, and they all use something slightly different, some slightly different variation. But there's been some convergence on H.264, which is the latest codec from the MPEG codec standards, and that's actually used in Blu-ray. It's used in web streaming. It's used in YouTube. It's used in cameras for video recording and so on. So it's widely used codec, but it is patent encumbered. And there's a licensing pool set up by the MPEG licensing authority, the MPEG-LA, that charges you if you want to use this codec. What Google did last week, Google has been supporting a fully open source codec, and there's a sort of chain of these that have been built over the years. There's Aura as a video codec, Vorbis is an audio codec, and the newest one, the new sort of bundle of these they're talking about, is called WebM, which is a variation of On2's VP8 codec, because Google bought On2 and then open sourced the codecs. So what Google has last year launched WebM as a non-patent encumbered codec that could be used by anyone on the web. That was taken up by Firefox for their browser, and Adobe said they'll integrate that in Flash, and in Google Chrome they support WebM and they support H.264 at the moment. And they said they're going to drop support for H.264 going forward to try and encourage people to use WebM instead.
This is all critically important as more and more video is flowing over the web as opposed to cable or satellite. Do you agree?
Yes.
So,
but also, it's the video. Even the video that's flowing over cable and satellite is now sent digitally and encoded this way. A lot of it is sent for the older MPEG-2 standard, but the newer stuff is sent with H.264 as well. Because at least pretty much everything is digitally compressed now. There's barely any analog broadcasting left, and the digital broadcasting is all compressed.
Right. So in a nutshell, what's going on here is someone is claiming patent rights in a broadly used video codec, and rather than debate or litigate or get mired up in that, what Google has done is say, you know what, we're just not going to go there. We're going to use something else. It's open source. You don't need to worry about being encumbered with patents. We encourage everyone to use it, and we'll avoid this whole conundrum.
That's what they've been saying. Now, Apple says the opposite. Apple has long had the position that the patents they've licensed are useful, and they're wary of what are called submarine patents, which are patents that people have hidden that will then emerge later. People will hide the patent, wait till something's built on it, and then sort of bring it out of the box and sue people. And this isn't a theoretical thing. This has happened over and over again in this field. There've been this whole series of patents from different, I can't remember all the names of them, but there's this procession of these where these people will turn up and say, I have a patent on this particular aspect of video encoding, and go around and try and shake down Apple and Microsoft and so on. And they've been fairly busy with that. And what they were concerned with here is that back like 7 or 8 years ago when I was at Apple, I was trying to get them to adopt the Vorbis audio codec for QuickTime. And the response I got from the VP there was, we can't do this because Fraunhofer or Dolby Labs or someone that we're licensing patents from for our DVD playback in the computers could injunct us against this and prevent us from shipping machines that play DVDs. That's not a risk I'm willing to take for the open source project. And what Google has said is, okay, we'll take that risk. Apple's position was the open source people are too small to sue. No one's going to bother suing them. Whereas we're Apple, we've got pots of money. Someone will come and litigate against us on the patents. And, then they did. They source, cut one of these every week pretty much.
Right. Just by virtue of using
Google's
something
basically
open
said,
source.
we're big enough, come sue us. Yeah.
Right. Just by virtue of using open source, though, aren't you always going to be subject to that submarine patent issue? By the way, I love that term. Dive, it's a submarine patent.
Yes.
You're just, people try their best to document the code that goes into open source projects, but there always seems to be some issue out there. It's just not ironclad.
We're seeing that with the Oracle, Google, Java suits at the moment, where, and to some extent, it's open source makes discovery much easier. There was the famous Apple Canyon lawsuit where Apple sued Intel and Microsoft in the late 80s because Intel had hired the same subcontractor Apple had used, and they'd reused the code. And so they'd shipped basically the core loops for their video stuff was the same across the platforms. And Apple successfully sued them and required them to stop shipping that version and make a new version that didn't reuse that code. And we're seeing similar stuff with the Google Oracle litigation, but it is much easier to do discovery on open source because you have the source. Without that, you've got to then you've got to get the source. You've got to either decompile it or get the source from that and put it in a clean room and spend a bunch of time on it. Whereas the same thing that makes open source easy to fix makes it also easy to find violations. My take on this is that Google is trying to move to a fully open source world. I think they've moved slightly too soon. I don't think that WebM is mature enough yet to displace H.264 fully, and we need H.264 at the moment. But they're clearly trying hard to do that. To some extent, they have called sort of Apple's bluff on this because Google is an eminently suable entity. They have fewer patents in this space than Apple do, and so if WebM was such a huge threat to the patent holders, they could have injuncted Google in the last 9 months since they launched that publicly, and they haven't done that. So, but it's the ongoing part of this is how do we standardize on this, and we've had this near de facto standard with H.264 inside MPEG-4 for the last couple of years. That was basically Apple adopted it for the iPod, iPad range, and the Macs as well, obviously. Google has been using it for YouTube. Flash has incorporated in Flash as well, so that the same codec, the sort of MPEG-4 files can be played back by a Flash wrapper, which is what YouTube uses on the desktop. And also, many devices now generate this natively. So your phone, when it records video, will quite likely be recording in H.264, and many of the cameras do as well. So there is a lot of there's a lot of hardware support specifically for this codec in those devices. So the challenge is to can you refactor that hardware to support the different, slightly different sort of model of how it breaks things into squares and moves them around that WebM has. So that's the sort of technical challenge, but the legal challenge is all around patents. And this is a sort of very messily litigated area. Video algorithms has had lots and lots of lawsuits going back and forth over a very long period of time.
Right. You mentioned Flash, and I was thinking of Kanye, the Flash rapper, as you said it. And I wanted to ask how Flash and HTML5 factor into all this, if at all.
Well, so they're sort of related. HTML5 is the replacement for HTML, and one of the things it adds is a video tag and an audio tag, which previously, if you want to do video and audio, you had to invoke a plugin and say, okay, I have an MP3 file, find me a plugin that can play that, or explicitly say, I have an MP3 file, play that with Flash, or play that with QuickTime, or play that with Silverlight, or whatever. What's happened in HTML5 is you're supposed to be able to use audio and video in the same way you use images. Now, you just put a tag in that says video, here's the file, and the browser will play it for you. But the challenge there is the browser then has to understand the file format. And there is a big debate amongst the browser manufacturers, which they support, which had split into two camps. So there was the Apple and Microsoft camp, which was ironically supporting H.264. And then there was the Google and Mozilla camp that was supporting WebM and Vorbis, and Chrome was supporting both. It's actually current versions of Chrome will play back both 264 and WebM. So they were, if you like, they were sort of the Switzerland. They would play anything on the web, and in my mind, that's an advantage for a browser. It'll play more. But what Google has said is, no, we want to stop this to actually drive adoption of the open one. So it's definitely a stand on principle rather than on market. And I'm slightly surprised by that, because I think, but there is also this sort of odd assumption that there can be one codec only, and that I think that's to ignore the existence of every other piece of video in the world. Every DVD has MPEG-2 on it. Every home camera that records video, many of them have older video formats. There's lots of this stuff out there, and there's lots of existing media in those formats. So at some point, you're going to transcode it. Now, in effect, YouTube is doing this. You can upload video to YouTube in about 15 different formats, and they'll convert it into, currently they convert it into H.264, and they're starting to convert it into WebM as well. And I've been trying, I just got a new Mac, so I've been trying out the default state that the MacBook Air comes with, which is the browser doesn't have Flash installed. So if I go to YouTube, it'll try and use the HTML5 video and the WebM.
The same as an iPad, correct?
Right, and not, half of them don't work. Google hasn't actually backfilled every video yet. I think they do it by popularity, but there's a huge amount of processing there. Now, if anyone can do it, Google can. They've got lots of computers and storage, but that they're basically, if the agenda seems to be, if we're going to take this format, we're going to take on the job of transcoding everything on Earth into it. And to some extent, YouTube is a big start on that, because people do upload things there and have them converted.
Right.
If YouTube is like a cultural library of video, and certainly I now assume that if I remember some advertisement or comedy clip from my childhood in the UK, I can go to YouTube and find it and share it with people on the internet, and that's very likely to be there because someone somewhere will have found it, digitized it, and uploaded it to Google.
Right. I don't know about you, Evan, but it makes me feel kind of, one of those moments where I feel kind of awful about being a lawyer and being involved in a system that has led to this, thicket of legal issues around standards that, has made it so difficult for people to just simply arrive at a standard that's going to be used across the board for video on the web and over the internet. Do you feel that way too?
Yeah, well, there are all kinds of reasons why you can have self-doubt about, being a lawyer, but you just kind of sometimes got to look inward and deal with that stuff. But yeah, no doubt. And I mean, in this really raises that question that we spend so much time thinking about, and which somebody just in the CR in the chat room just raised. A very fundamental question that goes to the real essence of the intellectual property system. Does patent protection hinder creativity, or does it enhance it? And Matt Macari, who's been a guest on TWiL, chimed in saying, there have been entire careers devoted to that question. And isn't that the truth? And not only have there been entire careers devoted to that question, but there are entire industries that are modeled around this. And, when you think of the entertainment industry and when we read articles like the ones that we've, been reading up recently about Netflix and its expansion and these huge content deals. Well, if you're going to ask someone who's the beneficiary of those huge deals, where they're getting checks for millions and millions of dollars by virtue of their ownership of this content, then they're going to think that intellectual property, by gosh, sure does enhance creativity. So, all of this depends on where you look at it, and if one's going to have a sour attitude about, being involved in creating this thicket, as you so colorfully describe it, I think one can just as easily kind of flip their perspective by 180 degrees and see it not a thicket, but, this wonderful expanse of opportunity and riches and then everything else.
If you're a patent
won't
troll, you
convince me about
definitely
that.
view it that way.
You won't convince me
Eric,
that way for software, really.
Yes.
Well, right.
Basically, what we've seen in software is that the patents there have broadly been used adversarially and not been used to protect invention. And there is a very large problem of people gathering up patents that were over generously granted patents and then making a business out of just litigating around them. And there's there've been very, very high profile cases. Microsoft has paid out billions of dollars in cases like this.
It's the way.
Eric
it's the way.
Robinson,
Patent
anything to add to this discussion?
Well, I think it's another example of what we were talking about before in a different context with the courts and media. These laws were created for a different era. Copyright protection can last now close to a century, and with with new technology, we really should take a look at how these old ideas and concepts should apply in this new way of doing things.
Yep, absolutely. Yep. Hey, Evan, you hit on the Netflix issue, which I think is more and more becoming worthy of scrutiny and consideration earlier this week. And sometime I would love to do, when I have time to listen to all the Twit shows in 1 week, I would love to do a roundup of all the legal issues that come up on every other Twit show, and then we talk about them here on TWiL. That would be a long show.
Right.
But when I do catch other Twit shows, I'm always finding good fodder for us to talk about here. And over on Frame Rate, Schwood and Tom Merritt had this great discussion about the Hollywood Reporter article on, sort of breaking private backdoor discussions about what executives say about Netflix and where it's going and how it's perceived. And, we have it in the show notes here at delicious.com/TWiL/95. If you want to read it in more detail, it's an extraordinarily interesting article with good graphs of how Netflix subscribers have grown from 1.487 million in 2003 to last year 16.9 million, and what the economic impact of all that is, and the deals that make Netflix possible. And so I wanted to throw that into this discussion and find out, particularly from Kevin, who's been paying attention to the distribution of web video from the inception of being able to do that. What you think about what's going on here, Kevin, and what we can expect in the future?
In the Netflix case, I think there's different layers to that, because there's a couple of attacks going on at once on Netflix. Sorry, there's the rights holders are now about to ramp up what they're going to charge Netflix for distributing stuff digitally, which is reasonable. That's that's reasonable use of copyright law. But there's also oh dear, excuse me.
All right.
I have a bit of a sore throat.
Hey, Evan, why don't we let Kevin take care of his throat and you chime in on this Netflix issue? And it's all about it's all bound up with the DRM question too, because if all of this was unwindowed, openly available, we'd be looking at a completely different world and business model. So it's all about how content is locked up and dribbled out from those who make it and hold the copyrights.
Right. And I see really kind of at least a couple of important points here. One is, this is a very sophisticated issue that involves a lot of specialized knowledge and a specialized kind of insider approach of understanding how Hollywood works and how, the content market, if we could want to characterize it that way, works. And given that framework and that context we're working on, a reasonable person can look at this situation and kind of realize we're at a real big transitional point here when it comes to the shift in the distribution of content in one setting or on one side of the equation being the broadcast model, television, cable, and on tangible media like the DVD and the streaming model, the digital model here. Given where the market looks like it's going here and these deals that are being struck with Netflix and whomever is going to be next to enter that space, whether that be Amazon or Google or whomever else would have the resources to really be a viable competitor to Netflix, kind of setting aside Hulu and Hulu Plus and whatever is going to happen with that Comcast, NBC Universal mess, all that aside, looking at it more broadly here, we're at a point where there's it's like the fulcrum and the lever where things are really switching into a new world that is characterized most predominantly by streaming media. And I suppose that's probably where you could work in the DRM issue, right? Is that what you're thinking of, how it changes the calculus for how content will be protected in the same way that it changes the way that it's distributed? Is that what you're thinking, Denise?
Yeah, definitely. I think that it's all dependent on people clinging to the world that we're used to, where things are very tightly controlled, and that we may find some content producers, well, the TWiT network is a good example. There's no DRM on these files. They're Creative Commons licensed. They're freely distributed around the web. And, it's part of our business model. It's part of why this works. And I think that, we may find more and more mainstream, widely available and popular content deciding to go that route. And, where do we wind up with that when you've got a device like a Roku that puts our programming exactly on a par with whatever's available on demand from Amazon On Demand, which is people don't really talk about Amazon On Demand as a competitor to Netflix, but having used it a lot in the last few months, it's very compelling. They're doing good stuff over there that is, at least as nice an experience as Netflix. It's not as widely available and on as many devices, but the pricing and everything, although it's a la carte as opposed to a monthly fee, it's very, very good. So I think that there's obviously no TWiT network. Then that it doesn't hold a candle to that. No, of course not. For all the cred that it comes with. Right, exactly. Well, all kidding aside, you may see more and more going down that road of, okay, we're just going to turn our back on the traditional distribution model and try something else and suck up audience that, is sick of dealing with all of this behind the scenes deal making and wrangling and lots of hidden or not so hidden pricing. Kevin, have you had your Earl Grey hot, as was suggested in the IRC, and are you feeling a little better?
I'm feeling a bit better. I've actually been sucking a cough sweet, so I can hopefully speak without choking to death. So I think that there's a bunch of weird stuff going on with this because, again, it's a technology transition. We didn't used to be able to store television at all. When I started out in television, we had videotape and that was it, but videotape was a professional thing. And before that, there wasn't any way of storing it anywhere. Now, every device naturally stores video whenever you do it. You can't help but do it, and the buffers get bigger. So now everything is making copies. And so we have this sort of weird legal fiction of streaming video, which is where the computers make a copy of the video on your local machine and then throw it away. And so pretend they haven't made one, and therefore that streaming has a different license from downloading.
Right.
And so we end up with this sort of weird situation where with DRM is like computer software that lies to you about what it's doing with the video. It just pretends that it's letting you watch it once and trying to enforce rules on what your computer's doing. So this is, it's basically maintaining a legal fiction through software. And and this is problematic because there's this sort of assumption that these two processes are actually different when they're not. And you can it's perfectly straightforward to record a stream of a video that's played to you through any of these systems, technically. So there's this sort of large myth going on that these are actually structurally different kinds of things. Because
it's not as straightforward, though, right? I mean, there is some basis for content owners sleeping better at night when something is streaming. It's a few more hoops to jump through for someone to be able to.
It's technically trivial.
Okay.
I'm speaking as the engineer.
Yeah, exactly. I don't know. If it's saved, somewhere where I can readily find it as a file on my computer, then that's one thing. If it's something where I have to download software and violate terms of service and all that stuff, then you might, as I said, have a few more hurdles.
Maybe the word technically was the key modifier to that statement, that it's technically trivial, right?
Yes.
Well,
exactly.
but the point is, the thing is, it's not like every person has to do this. I can write a piece of software that would capture the stream that we're watching off the screen and record it to your computer and give that to you as a plugin that would run on your computer, and then you'd be able to do it the same thing I can do. It's the same issue as propagating the recorded video is propagating the code. And the other thing is that
doesn't go away either way, you're saying.
Right. And the ability to record doesn't go away either. This is the, if I want to watch Doctor Who, I can wait till they sell me DVDs. I can wait till they give some butchered version of it on BBC America, or I can download it an hour after broadcast from the UK and watch it in full quality on my computer. And once you've actually broadcast anything, the digital recordings exist and will not go away again. And that's that's the truth now. And and it's been somewhat true for a while. There's this sort of horrible gap in the BBC archives where they started erasing videotapes because they hadn't actually come up with a good archive policy, and so that big chunks of the 70s and 80s are actually missing from the archive. And for a series like Doctor Who, which has continuity that goes back to the 60s, what they've been doing is gathering up bootleg recordings from amateurs in other countries and trying to reconstruct the shows that they've actually lost. And even going back that far, they found tape recordings of people who'd filmed the screens and things like that in other countries around the world. Now, if you wanted to if you lost the master tape for a TV show, you could reconstruct that from all the TiVos around the world, or any recording that people had downloaded it, and or just go to the BitTorrent archive and get a nice clean one that's probably better quality than the thing you broadcast originally.
Right. So, Eric, do you think that we're going to see U.S. Supreme Court proceedings showing up on BitTorrent anytime soon?
Well, first they'd have to get a camera in there, which the justices don't seem to be too keen on. I think it's inevitable. I mean, it's probably almost all. There are probably a few exceptions. State Supreme Courts now have, small cameras. I was in the Nevada Supreme Court the other day. They actually they collect your cell phone when you go in, but they have cameras in the courtroom. It's just a matter of time as, let's face it, judges tend to be senior lawyers who are more traditional and less familiar with new technology. And as younger judges get on the bench, they'll be more accepting of these sorts of things.
Yeah. Well, guys, we've been going on for quite some time, and I would love to go on all day. There is one more topic I want to hit before we wrap, because I have Kevin here, and I really want to pick his brain about it. It's something we've both followed for a long time, and it is the question of your identity online and who manages those identity systems. And it's a big, thorny, complicated topic. I don't want to spend too long on it, but we have a couple of discussion point stories. Number one, the Obama administration and its proposed internet ID system, and also the growing role of Facebook as the de facto internet ID system as more and more people use Facebook Connect. And Kevin, I just wanted to see, you know, what you think about all this, and if there are other alternatives that show any promise of actually managing this issue.
Well, I think there's, you know, what the government announcement said was that they wanted industry to provide something. They didn't say they were going to legislate one, and there was some confused reporting about that.
Right.
But what they were broadly saying was that we should be using OpenID, which is the standardized way of identifying yourself as a URL. And that's in broad use by, you know, pretty much everyone, Google, Yahoo, Microsoft, every blogging service and so on uses OpenID. But what that doesn't provide as rich data as you get from Facebook, because Facebook also has a list of all who your friends are, some rich profile information and so on. All that OpenID gets you is an URL, and you have to do some other stuff to get hold of that. And one of the things we're trying to do in this standard space is agree on ways of standardizing some of these other pieces. So your graph of connections, your profile information, and we have specs for that have, again, got reasonably broad adoption, but not necessarily, you know, everyone. But also trying to combine it with the authorization that's OAuth. So when you sign up for something with Twitter or Facebook now, it uses a protocol called OAuth, which authorizes the application to have a limited access to your profile. And so that is actually a sort of better because it lets you get more access, but each company potentially has its own format for that profile data. So what we're trying to do in this world is to unify these two, combine OpenID with OAuth, such that you can readily get the minimal information of this is the person, here's their identifier, here's their you know, photograph and name and contact details, and be able to bootstrap that into the broader connections that you can get through these systems where you've already specified your graph, and you get to choose which sites get to see what from that. And a lot of that is technically there. What we don't have is sort of strong user understanding of what you're sharing when. That's the much trickier part to solve in that. But there is some degree of standardization on this, and there's, you know, it's a continuous attempts to try and do more of this, and with reasonably good faith behavior by Facebook. They employ David Ricordan there, right, who's on the OpenID Foundation and works on these standards, and is trying to, you know, unify what they've designed and what they model with the sort of the broadest standards there. So there's some progress in that respect. The challenge is always between is there a competitive advantage by having a proprietary thing, or are we better off, you know, having a interoperable thing? You know, are we better off having a closed system for communicating, or are we better off having email? And broadly, we're better off having email and an open system. But the challenge is setting up in such a way that it isn't, you know, vulnerable to spam the way email was, doesn't have the spoofing issues that email has.
Right. I mean, I think that people who watch and listen to this show are, you know, prone to be like Jason Watkins over on our Facebook page, where we post up pre-show questions. I asked if single sign-on's convenience was, you know, going to be the day carrier, or whether people would avoid it in the name of something less centralized and siloed, to try and preserve whatever's left of your anonymity and security. And Jason Watkins says, yeah, I would avoid it. I have no problem remembering credentials for different accounts as necessary. Multiple accounts, providing one uses different passwords for each, can provide a type of defense in depth for that kind of access. Yes, but does that mean that everyone else out there, when they see the, you know, sign in versus connect via Facebook option, you know, what are you going to do? What do you do, Evan?
I pretend like the sign that connect via Facebook is not even there. I mean, that's just.
Do you really?
That's just, yeah, it's insane to me that I would, open up my Facebook information in vectors that I, don't know, the full notion or the full scope and breadth of. I'm so skeptical of Facebook anyway. Just within the Facebook ecosystem, when it gets spread out across the web, that just makes it even more bothersome. So it doesn't bother me to remember multiple usernames and passwords, and when the same kind of sensibilities makes me upset, skeptical at least. With the whole proposed online identification system here, because the thing that I just can't get my mind around, and this may be a real kind of simpleton type of objection to this, but hopefully that, the simplicity of my objection is based on the lack of knowledge as to what the heck this thing actually is going to be, is, if there's one point of failure here, what's going to happen if that, single identity is compromised? You're effed, across the board. It'd be worse than having your social security number disclosed to everyone, it seems to me, because not only is there this notion of identity, but there's the identity plus the ability to do stuff with it.
Mm-hmm. Right. Well, that's the point of the OAuth standard is to let you selectively give different permissions to different people who attach to the service. The alternative that is widely used at the moment is that the site asks you, what's your login, what's your password for this service, and then they can completely pretend to be you and do anything you could do there. And that is what we're trying to get rid of, because that is much more dangerous. When Facebook says, give me your Gmail account and your Gmail password so I can get your email out, or vice versa, you're basically trusting, or you go to some game site and it says, give me your email address and password so that I can find your friends on Gmail. You're basically giving the ability to completely impersonate you at Google, and potentially access your Google credit accounts, your AdSense accounts, and other things you may be able to do there. So you don't want to give every program the ability to impersonate you completely. You want to selectively give them smaller permissions. And we have technology that does that. That's what OAuth is about. But the challenge is always explaining to the user what they're signing up for. Right. And we've seen this. If you give people, you either give them a screen at the beginning and they go, I don't understand what you're asking me. I just click yes, like the original Facebook dialogue where it gives you this app wants X, Y, and Z. Or when you install an app on Android, it says it has access to these services. And the point when you're doing that, your mental model is, I don't care, I want to get this thing done, and you don't do that. Or the other track is the sort of the Microsoft Vista thing of every time you touch something, it says, this computer is trying to do something you wouldn't like. We want to say yes or no. And again, you get sort of tracked into saying, yes, for God's sake, let me get my job done. And so the challenge for this is always explaining to people in the right context what they're permissioning here. And that's the piece that we need to work on. We now have the technical ability to say you only have, it's called capabilities. You say the program has access to this capability. It is able to see your camera. It is able to see your phone number or whatever. It's able to touch the internet. So the combination of that is it can take photographs of you, send them to the internet, and label them with your phone number. That may be troubling to you. So you may not want to grant that permission. But if you get, the consequences aren't always clear when you just get a list of what it's asking for. And so making sure that the app is asking for the right degree of permission. If it is an app, if it's Skype, then having your camera and email address is a legitimate thing for it to have because you want to use it for communication. If it's just some game you're playing on your phone, it really doesn't have any reasonable need to have that stuff. So you probably don't want to grant that. But understanding what you're granting is this harder problem.
Yeah, I think that's where we're going to see Congress step in at some point before too long and take a hard look at what Facebook has and how, impose some obligations on them about how that information can and can't be used. And not just Facebook, but, any service provider that gobbles up things like, your credentials for other services.
Right.
Is there anyone else besides Congress that could act on that? You know, could the Department of Commerce or the FTC accomplish what we're talking about here in doing some of the things that it's talking about? Maybe the first cousins of the do not. Wow, there's some weird. Are you guys hearing that too?
Yes, it's a patent submarine going by.
My phone was ringing. Sorry.
It was really strange. I thought I entered some kind of ambient alternative universe that really kind of went straight through my brain. So, and it wiped my memory clean. I have no idea what I was talking about.
You're talking about the FTC or somebody else.
Oh yeah, that whatever privacy.
Who else could move on privacy and I'm not sure. Potentially, you can talk about it as interstate commerce and stuff like that. You could start using those kinds of rules, but it's a bit difficult, particularly when people have voluntarily given the information over. So in the EU, they have much stronger data protection rules about what you're allowed to disclose to whom and who's. If you're allowed, whether you're allowed to collect personally identifying information and correlate it with other information is much more tightly regulated in the EU than it is in the US. So
right. Well, yes and no, because so many. I mean, yes, you're right. Absolutely, the EU directive is much more comprehensive, and that's the European way of life. Regulating it prospectively like this. But I mean, in all reality, aren't a lot of U.S. companies probably held to the same kind of standards because of they've sailed their ship into the safe harbor with the EU? I mean, if you look at companies like Oracle, Amazon, Facebook, those. I mean, who have all, when they're getting information from EU citizens, they, in order to be fully compliant, they have to self-certify that they follow, the 7 principles that are in the EU directive and all that stuff. So I mean, our data is perhaps more secure when it's with U.S. companies, not because of U.S. law or the fear of the Federal Trade Commission or whatever, but it's because the EU has made it a practical obligation of these companies to sail their ships into the safe harbor. So it seems to me that there could be something done regulatory, and I don't know exactly what that is. It seems like there could be something done regulatory in the United States by the Department of Commerce or the Federal Trade Commission or something that would elevate the standards that we have that would alleviate these concerns without getting Congress involved and blunderbussing it up and really messing it up for all of us. That's what I fear most is, are the people that we elect who have such a political motive, to do something that's really going to mess it up for us.
I mean, the challenge is that we already have much scarier companies, that the credit rating agencies and things like that are both gathering information on you, keeping giant databases, and largely making it up. And they are, for me, scarier than the stuff I put in Facebook or Twitter.
For sure.
But the other thing is when they start correlating the two together, that even gets it's more worrying. So I'm not completely convinced we have a great legislative track record here. Credit bureaus have been around for 30 years, and there's still. There's the ability to see your record and a few things like that, but there isn't good protection about being able to move it between them, is there?
Right.
Eric was wanting to say something.
Yeah, I just want to. I think a fundamental problem here is that although we all talk about privacy and we all have a concept of privacy, legally, privacy, at least in the United States, is a pretty amorphous concept, and it doesn't. I mean, it comes out of various interpretations of various provisions of the Constitution and statutes and things like that. And so, I mean, I agree with Evan that once you get Congress involved, that really is going to be, shall we say, an interesting process.
Yeah, they paint the strokes that they paint in are too broad. That's the problem.
Right. And the FTC is reviewing COPPA. And, as they tweak that to come more in line with what's going on with the gathering of kids data today, maybe that'll have some broader impact as well. But I think that's about all we can do on that topic today. It's one, again, where we could go on and will on other shows. But today, I think we're going to wrap it up and let people get to their weekends. But I've really, really enjoyed speaking with you all. Eric, it's been a great pleasure meeting you virtually on our show and learning about what you're doing in Reno. And hope folks will go check out the Reynolds Center. There are some great resources there and on this important issue of courts and the media. So thanks so much for joining us.
Thank you. And, it was great being on.
Folks can follow Eric on Twitter. He is at bloglawonline over there, and his blog is at bloglawonline.com, and also the wonderful Citizen Media Law Project, the blog there that covers all things related to citizen media and the courts. And another issue that I'd love to get to in more in depth, maybe on the next show, the documenting of our law enforcement officers as people go around with their electronic devices, but we're simply out of time today. So thanks so much, Eric. We'll talk to you again soon, I hope.
Thanks.
And Kevin, I'm so glad you finally, we were 95 shows into it and I finally get you on the show. I can't believe, you and I had started our blogs sort of side by side. I think of you as my blog neighbor.
Almost 10 years ago, isn't it? Yeah.
Yes, exactly. It was. So I'm really happy to finally get the chance to see you again. It's been way too long, and really appreciate all your insights on the show.
Thanks very much. I really enjoyed it. Very interesting conversation. I'd love to do it again sometime.
Yeah, I'd love to have you back. Kevin, of course, is Kevin Marks on Twitter, and his blog was then and still is at epeus, epeus.blogspot.com.
That's right.
Take care.
Bye.
Evan, wonderful show again. Thanks so much for joining us.
Thanks a lot. It was a lot of fun, wasn't it? It was really, really great conversation. Great to meet you, Kevin. Great to meet you, Eric. Let's stay in touch.
Yeah,
definitely.
I'm sure.
And right now we're gonna take this submarine down to the bottom of the depths and let you dive on into your weekend. But thanks for watching TWiL and the Twit Network, and we'll see you again next week at 11 PST, live.twit.tv. Take care, folks.